Welcome to Legal Innovation Spotlight, the podcast that brings you the latest advancements in legal tech and knowledge management. I'm Ted Theodoropoulos, and I connect with the industry's brightest minds to provide you with valuable insights and actionable takeaways. So sit back, relax, and let's dive in. Damien, how are you this afternoon?
Couldn't be better. Life is really good. How are you, Ted?
I'm doing great. I appreciate you joining me this afternoon. We were kicking around a really interesting topic via LinkedIn, and I figured, you know what, this is I've been overdue to have you on the podcast anyway, so I figured this was a good opportunity to riff a little bit. But before we do, let's get you introduced. So I went and looked at your LinkedIn profile. Interestingly, I didn't realize you started your legal career as a clerk, and you started practicing in the early 2000s. You worked for TR and Fastcase, that's now VLEX, right?
That's
right. You're still at VLEX, and I know you do a lot of work with Sally. That's how you and I actually first met. But why don't you tell us a little bit about who you are, what you do, and where you do it?
Sure. I've been a lawyer since 2002, so I clerked for chief judges at the state appellate court and the federal district court. Then I worked for a big law firm, Robbins Kaplan, where I represented Best Buy in much of their commercial litigation, represented victims of Bernie Madoff, helped sue J.P. Morgan over the mortgage-backed security crisis. So I have a pretty long time, some would say too long, as a litigator. But then I've also been a coder since '85. So I have the law plus technology background. And anyone who works with me will tell you that I am probably the worst coder you've ever met. So I say I'm a coder not as a badge of honor, but a shroud of shame, where I'm not very good at coding at all. But with large language models, one can be actually better at coding than one actually is. So after litigating for a bunch of years, joined TR, building a big thing for them, did cybersecurity for a while. But since 2019, I've been working with Fastcase, which is now VLEX, doing essentially playing in a playground of 1 billion legal documents, cases, statutes, regulations, motions, briefs, pleadings, extracting what matters from them using Sally tags and otherwise, and then running large language models across those things.
Interesting. And is that how your involvement in Sally came to be, was the work that you're doing at VLEX?
It actually came to be that I met Toby Brown, who founded Sally in 2017. I met him at ILTACon, and we just happened to sit in the same breakfast table. And I'd known of Toby, but had not actually met Toby before. But then we started talking a bit about Sally, and I said, you haven't really chased any litigation things. He said, no, we haven't. I said, why not? I said, would you like some help on that? And he's like, well, it's too hard. Do you want to do it? And I said, yeah, I totally want to do it. So we met in 2019, August of 2019, and I've been working on Sally ever since.
Interesting. And what were you coding in 85? I started coding in like 82. What were you coding? Basic?
I was coding BASIC in my Commodore 128. It was I didn't start with the Commodore 64 because I wanted to get the thing that had 128K of RAM instead of 64K of RAM. So I was coding BASIC. I was getting magazines where I would take the magazine on paper and I would recode the code in the magazine and try to tweak the code. So yeah, I was a very nerdy 10-year-old.
Yeah. So it's funny. A lot of parallels there. I started off with a Commodore 32. So I had 1/4 the memory that you did. And, I used to have to store my programs on audio cassette. This is before I could afford a floppy. And, so this would have been, probably 82, 83. Then I graduated to I had a TI 99 4A with a extended basic cartridge and a book about that thick. And I literally read every page of it to understand all the new commands. I totally geeked out on it, and then was totally into it. And then during middle school, the girls didn't think it was cool to be a computer programmer. So I kind of ditched it for a while until college. So I had a break in there, but then when I picked up computers again, it would have been early 90s, like 91-ish. And by then it was Visual Basic, doing native Windows development like VB4. I can't remember. I think it was Visual InterDev, and used to compile Windows programs. I did a lot of SQL. I was actually on the SQL team at Microsoft in late 90s, early 2000s. So I can still hold my own on SQL, but I'm like you, man. If I had to if I had to code an app, I'd be so lost right now.
It's true. And really query how important that is these days to be really a hardcore coder. I know people that are really good hardcore coders that use things like Cursor and use large language models to be able to be a bicycle for the mind, like Steve Jobs would say, and make them go better, faster, and stronger. But even for people that are rusty or really awful, like you and me, it's still I can't go 10 times as fast as a normal coder can with a large language model, but I can maybe do 1x what they used to be able to do. Right? There's really it really evens the playing field on what is possible.
Yeah. Well, you and I were riffing on a topic that I think is super interesting, and I was kind of surprised to hear your perspective on it. And I thought it was really interesting. And we were talking about the question on whether or not LLMs can reason. And I've always, understanding the architecture, I've always just had the default assumption. That's kind of where I started my position on this with there's no way they can, just based on the architecture, right? It predicts the next token. It has no concept of comprehension. Therefore, reasoning seems to be far out of reach, but it does create the illusion of reasoning. You had an interesting argument, which was, does it matter? So, I mean, let's start with, do LLMs reason or create the illusion of reasoning?
And yes, let's talk about that. I think a good precursor to that question is, are LLMs conscious or are they not conscious? And that's another kind of academic exercise, a question that people have been thinking about. It gives the illusion of consciousness, right? But of course, large language models, in my opinion, are not conscious, right? Because they are just mimicking consciousness. But their philosophers for millennia have been saying consciousness is undefinable. Like, the only thing I can be conscious of is that I know that I am conscious, but whether you are conscious or not, or just a figment of my imagination, is something I will never, ever know. All I know is that my own consciousness is a thing. So I think the question of whether large language models are conscious or not is kind of just an academic exercise that really doesn't matter, right? Any more than I know whether TED is conscious or not. That we as science and we as philosophers have never defined consciousness. Therefore, the debate about consciousness is just an academic exercise. So let's now set consciousness aside, and now let's talk about reasoning. And the real question is, when I'm speaking with you, Ted, I have no idea whether your brain is reasoning or not. That's because often we ourselves don't know how our brains are reasoning or not. The only way I can tell whether Ted is reasoning or not is through the words that come out of Ted's mouths or the words that come out of Ted's keyboard as Ted is typing. And if those words look like reasoning, and if they quack like reasoning, then I could be able to say Ted is probably reasoning. So maybe shouldn't we judge large language models in the same way? That if the output of the large language models looks like reasoning and quacks like reasoning, then maybe it's reasoning. And that's what large language models, machine learning scientists, data scientists, call that the duck test. That is, they know what goes into the black box. They have no idea what happens on the inside the black box, and they know what comes out of the black box. But what if the output looks like reasoning and quacks like reasoning? Maybe whether the black box is reasoning or not matters not, just like it doesn't matter if I know how you are reasoning in your brain. All I know is your output too.
Interesting. Can we test for reasoning?
Yes, I think we can. And the question is, what are the tasks that you're testing on? There are objective tasks, mathematical tasks. So you can imagine a mathematical proof. You could be able to test whether it's making its way through the mathematical proof or not. You can test whether that is reasoning or not reasoning. Same with science. Is it getting science correct? Is it doing the scientific method correctly? Is it reasoning? Is it providing true causation rather than mere correlation? I think that those are objective truths that you could be able to see reasoning. And I would say that the outputs for law are much, much different than that. That is whether I made a good argument or not in front of this court is not objective. That is subjective. So I can't do a proof as to validity or invalidity any more than you could do a proof as to lawyer one made a better argument than lawyer two. Ask 10 lawyers, and you might get a 50-50 split on whether lawyer one made a better argument or lawyer two made a better argument. Going over to the transactional side, the contractual side, lawyer one might love this clause, but lawyer two says that's the worst clause on the planet. There's no objective standard as to what is good legal work. And absent any objective standard as to good legal work, maybe what is good legal reasoning is in the eye of the beholder, much like beauty is in the eye of the beholder. That with absent any objective way to be able to say this was good legal reasoning or bad legal reasoning, I guess the question of whether a large language model is providing good legal reasoning or bad legal reasoning is unanswerable in the same way to say whether that human is doing good legal reasoning or bad legal reasoning. So I think this whole debate about reasoning or not reasoning is academic at best, because we should judge it by its outputs. And different lawyers will judge the outputs differently with humans, and they'll judge it differently with large language models.
Okay, I think that's true to an extent. But let's say I come in as an attorney, and to make my closing arguments, I sing the theme song to Gilligan's Island. I think that would universally be graded as this is bad legal reasoning, right?
That's right. That's right.
So there is a spectrum, and obviously that's an extreme case, but I think extreme cases are good to evaluate whether or not something's true. And so, yeah, I mean, if something is just universally looked at, every attorney, reasonable person that would evaluate it says it's bad. Does that monkey wrench what you're putting forward there, or no?
Yeah, that's right. So you're right that it is a spectrum, that you have the worst argument on the planet, which is just gibberish. And then there's the best argument on the planet that is going to win 100 out of 100 times, right? And same thing with contracts. There's the contract that's going to get the deal done 100 out of 100 times, and there's the contract that is going to fail, right? 100. So everything is along that spectrum. And then if you add a y-axis to that spectrum, there is a most common things, that is the head, and then there's the long tail of rare things that happen. So if you think about what the large language models are doing is largely giving you the head distribution. That is the most common things, because it's giving you a compressed version of the training data set. And so the head is almost never going to be Gilligan's Island. And the head is almost never going to be some of the worst, contractual arguments ever made. It's going to fall on the average on that side. And that actually is probably the right thing to do for the large language model in the legal task, because you want the average, because you want 100 out of 100 lawyers. You want most of the lawyers to say that's probably right. And that is the average distribution of this. And so really then, if we then say the x-axis and the y-axis, and you have the head, the most common things, and then you have the long tail, and you now say, okay, the large language models are going to take the head, not the long tail, then you have to say, okay, what is that head? Does it require legal reasoning or not? So let's talk about mathematics and science. We want to find new science, right? We want to be able to create new cures to cancer, right? And we want to be able to do things that have never been done before. So does the large language model need reasoning for that? Absolutely, because that's not part of the training set, right? That's not part of something that we can look backward at. So we need reasoning for new science. We need reasoning for new mathematics. You need reasoning for something that's never been done before, that you need somebody like Einstein or somebody who is once in a generation to be able to go forward and leap forward. Contrast that with the law. How much new thinking do we really need to do in the law? In contrast, how much of the law is looking backward, that is looking to precedent? If I am a lawyer arguing in court, if I say, I've got this really brand new idea that nobody's ever won on before, but I just sprouted it out of my brain, what do you think? The judge is going to say, show me a case. And if I can't show him a case, if I can't show her a statute, I lose, because it's not based on precedent. So do we really need new things in litigation? Do we really need new things in transactional work? Do we really need new things in advisory work? Do we need new things in regulatory work? And I think the answer to all four of those is no, because you're always looking to precedent, you're always looking to statutes, you're always looking to something that is in the data set. So if it is in the data set, really all of our reasoning that is legal is backward looking, not forward looking like in mathematics or in science. It is all backward looking. So if it's all backward looking, is every legal reasoning merely recombining the data set that we're having?
Well, what about novel pieces of regulation that now have to be interpreted? Are there not new legal? Is there not new legal thinking that has to take place to evaluate the applicability in those scenarios?
There is, but I would say that that is taken care of through what's called interpolation. And so with the large language models, they connect concepts. So I'm gonna can I share my screen on this?
Yeah.
And is it possible? Cool. So I'm gonna pull up a PowerPoint to actually demonstrate a real live case that I had, where there's so for the less sophisticated and maybe more sophisticated, we'll recap on how large language model works. Is that they pull out concepts and they pull out concepts and put them into what's called vector space. And so you can imagine a two-dimensional vector space that the ideas of a faucet and a sink and a vanity are probably pretty close together in that two-dimensional vector space. And then you could be able to say, okay, let's go ahead and put that in three-dimensional vector space with a z-axis. And then you could be able to say, okay, these all similar things are kind of clustered together as ideas. And now add a fourth dimension. And our brains can't even figure out what that fourth dimension would look like, right? Now add a 10th dimension. Now add a 100th dimension. Now add a 1000th dimension and add a 12,000th dimension. And 12,000 dimensional vector space is where large language models live, right? And somewhere in that 12,000 dimensional vector space lives Ernest Hemingway-ness and Bob Dylan-ness and Pablo Picasso-ness. That lives in 12,000 dimensional vector space. So all of the things that are legal concepts live somewhere in that 12,000 dimensional vector space. And all the facts in the world live somewhere in 12,000 dimensional vector space. And so what you can imagine is, to your question, isn't going to combine some novel things. I would say, yes, it will combine them. But the thing is, how many of those things are already in the large language model's vector space? And then combining those is what's called, the data scientists would say, connecting the latent space between those two disparate concepts. So now, as I'm going to be sharing my screen, this concept is to think through. A friend of mine works for an insurance company, and she asked, "What do you think of the thing about that called effective computing? What do you think of effective computing?" And I said, "I'm a pretty technical guy, but I'm sad to say I don't know what effective computing is." So what I did is I went to the large language model. I said, "Define effective computing in the context of insurance and the law." And she's an insurance in-house lawyer. So it says, well, effective computing is how computers recognize human emotions and facial expressions and voice patterns to create emotionally aware agents. I said, cool. Now analyze how effective computing can be used in an insurance call center, because that's how my friend's company was thinking about using it. And they said, well, you could use it for emotional recognition, figuring out the caller's emotional state, figuring out their choice of words, how quickly they're speaking, how emotional they are after an accident or loss. I said, cool. Now give me a list of potential legal issues that could stem from using effective computing in a call center. And they said, have you thought about privacy law, like GDPR or EUP or CCPA? Have you thought about consent and whether that caller consented to you analyzing their emotions? Have you thought about if you get hacked? What if all of your client's emotional data is in the hands of a hacker? What's that going to do legally? What's that going to do with PR? These are all good legal concepts. And I would guess that 0 times has anyone ever asked about the legal aspects of effective computing. But what it's done is it knows what effective computing is, and it knows what privacy law is, it knows what consent is, it knows what data security is. So it's connecting the latent space between the concept of effective computing and the concept of privacy law. And it then says, oh, give me some sub-bullets. And now it's going to continue expanding upon the concepts of which jurisdictions people are calling in from. What types of data? Third-party sharing? Are you minimizing the data? Each one of these things that I had lives somewhere in vector space. So merely combining the concept of effective computing with the concept of privacy law and consent and data security, that way we can then combine those aspects in new ways that haven't been in the training set. So I think that's where it is. Almost everything that we do as lawyers, everything we do is connecting my client's facts to the existing laws, and your client's facts are almost certainly in the training set. And the existing laws, if you are training on actual non-hallucinated cases, statutes, and regulations, those are also in the training set. So really reasoning is just being able to connect those existing facts in the data set with the existing laws in the data set and saying how they relate to each other, if you have the actual non-hallucinated cases, statutes, and regulations.
That's super interesting. So I find it, I have to think through this, but it seems shocking to me that there are no novel concepts that what you've just described, two things that currently exist in the training material, right? That the LLM has vectorized and plotted in 12,000 dimensions, and it knows the associations and the latent space between them. But what about new areas of law, like when we start selling real estate on the moon? You know, that obviously at some point will make its way in, but until it does, how will it navigate scenarios like that?
So I guess the question is, where do those areas of law come from? And they come from regulations. They come from statutes. They come from cases. And if those cases, statutes, and regulations are reflected in documents. And if the system has those documents, the cases, the statutes, and the regulations, then the system will be able to plot those in vector space and then be able to take those legal concepts and apply them to the factual concepts that are also in vector space. So really, every single area of law is written somewhere. It has to be, otherwise it's not a law. And if it's written, it can be vectorized. So really, everything that we do is part of the training set. There is really no novelty that is needed in the law because everything is necessarily backward looking at the cases, the statutes, the regulations that are binding.
Interesting. You had a metaphor I had not heard before with anesthesia, and I think you had a friend who was an
Nurse
anesthesiast.
anesthetist.
Yes,
Yeah.
and I have trouble saying that word, so I'll just say anesthesiologist.
Yeah.
To explain that, because I thought that was an interesting metaphor.
Yeah, she told me something. I was over a campfire and it freaked me out, and it may freak out your listeners.
It freaked me out too. Yeah.
Yeah, she said, Damien, do you realize we have no idea? She's a nurse anesthetist, right? So she puts people under every single day, and she has I think, a master's degree in anesthesiology. So she said, do you realize we have no idea how anesthesia works? I said, wait. Say that again. She said, yeah, one of two options. Option number one is it does what everybody thinks that it does, is that it puts us to sleep and we don't feel that scalpel going into our bellies, and then we come out and we're all fine, right? That's option number one. Option number two is we feel every single cut. And what anesthesia does is to give us amnesia, to make us forget. We don't know whether it's option one or option two. That scares the crap out of me, and it might well scare the crap out of you. But the question is, do we not use anesthesia because we don't know how it works? No, of course we use anesthesia, because the real question is, does it work? And is it effective as to what we would like it to do? If the answer to both those things is yes, then how it works maybe matters less than the fact that it does work. So apply that anesthesia test to reasoning. And just like I can't tell whether you're reasoning in Ted's brain or not, but I can gauge you by your output, by your speech, by your words coming out of your keyboard. And if that works, I say you're reasoning. And whether I know how your brain works doesn't matter, and whether I know whether anesthesia works doesn't matter. Whether I know how anesthesia works doesn't matter. The fact that it does work matters. So the fact that a large language model does create output that seems like it is reasonable and is reasoning just like a human is reasoning. If the large language model output is indistinguishable from Ted's output as reasonable, then I would say whether it is actual reasoning and how it's reasoning doesn't really matter any more than anesthesia doesn't matter if we know how anesthesia works.
Yeah, that is disturbing to think about. But it's a valuable metaphor. Now, here's what I would say in response to that. Did you have a chance to look at the Apple Intelligence team's study with the GSM 8K?
Only in the 2 minutes before you sent it. So why don't you describe it, and
okay.
maybe I can react to it.
Yeah. So it's only 5 weeks old, so it's very new. But one benchmark that has been used pretty widely to test reasoning in large language models is the GSM, which stands for Grade School Math 8K. There's 8,000 of these questions. And what Apple did was modified these questions ever so slightly and evaluated the LLM's performance against those modifications. And it was pretty dramatic. So their conclusions were, it said the performance of all models decline when only the numerical values in the question are altered in the GSM symbolic benchmark. That's pretty interesting. It says their performance significantly deteriorates as the number of clauses in the question increases. And then its conclusion is we hypothesize that this decline is due to the fact that current LLMs are not capable of genuine logical reasoning. And I thought there were a few examples in this specifically that really, I guess, were telling. So let me see if I can find this here. So one of these these are word problems, and in one of the word problems, I'm not going to be able to find it, but I remember enough about it to articulate it. What they did was in the problem, they threw a sentence that had nothing to do with the problem itself, and it completely blew up. The problem, the sentence that they put in there was, the question was something like, if the current price of keyboards and mouse pads are $5 and $10 respectively, and inflation has increased by 10% each year. That was the part that had nothing. Tell us what the current price is, right? It's already given you the information. The fact that inflation increased 10% has nothing to do, and it plummeted the accuracy of the large language model's responses. Something like 65%. It varied wildly, as you would expect. The latest models did, in the chain of thought, they did the best, but it seemed to me that this really pokes a hole in the whole concept of because what that points to, if you throw a sentence that has nothing to do with the problem in, and that means I haven't comprehended the problem. I don't know what the problem is, right? I'm simply reciting answers, and it's what I honestly would expect from, but I don't know. What is your response to that?
Yeah, so I would say two responses. One of which is the idea that mathematics has a right answer and a wrong answer, whereas legal often does not. That is, in litigation, it's whatever argument happens to win, and in transactional work, it's whatever gets the deal done. So where in the mathematical proof, you have a right answer or a wrong answer, whereas in legal, there's the eye of the beholder, where there is no objective, there's merely the subjective. So that's thing number one. Thing number two is, of course, with mathematics, you want to be able to create new mathematics and be able to go forward with new scenarios. But again, law never has, it's always looking backward to precedent, looking backward to cases, looking backward to the contracts, like we've always done the contract in this way. And we know that in this industry and this jurisdiction, force majeure clauses need to be in this way. This is always backward looking. So really, so two things, non-objectivity in the law where there is objectivity in math, and backward-looking in the law rather than forward-looking with mathematics. Yes, it'll throw off the mathematics by throwing in the inflationary tool, and it won't really reason in that way. But I think for our use cases in the law, whether it's a transactional use case, a litigation use case, an advisory use case, or a regulatory use case, all of the stuff is there. And if we use the chain of thought, like you talked about, then it could probably overcome the lack of true quote unquote reasoning that we have. And we as humans are really good at separating wheat from chaff. And so you can imagine, scenario one is everybody takes the robot's output and doesn't touch it. That's a bad scenario under anybody's estimation. But almost everybody's in scenario two, where it gives an output and then you look over that output and get it out the door. Under scenario two, you're going to separate that wheat from the chaff. And so until we have autonomous legal bots, which God help us if we have that, right? Until we have that, you're always going to have that human oversight. So really, whether it's reasoning or not, is going to be pretty easily flagged.
Yeah. And it wasn't just, there were other ways that they tested it. They actually changed some of the numbers. What was interesting that also threw it off, and this part surprised me. I thought LLMs would figure this out. They changed the names. So instead of Sophie, they put Lisa, right? But they did it consistently throughout. Like, it should be able to. So anyway, it's a new study. There's still a lot to be analyzed from it, but I did think it was interesting. Speaking of studies, the Stanford study. There's been a lot of conversation about it. The second iteration of that came out in May, and there was obviously there's companies out there that put a lot of money and effort into these tools, and Stanford was pretty pointed in their commentary, and there was a lot of feedback that the study was biased. I read it multiple times. It's about 30 pages, and it's an easy read. Like, reading scientific papers is usually rough going. That one was really easy to read, and I thought I didn't see the bias. It did try and trick the tools, but it was upfront about that. Just like the Apple study tried to trick AI, right? That's kind of part of testing, is evaluating. You're going to throw curveballs and see how the model responds. But I don't know, what was your take on the study? Did you feel there were biases, or what did you think it was fair?
Two thoughts on that, and not to throw shade on the Stanford folks, but you can imagine that one issue I have with them is that the terminology that they used for hallucinations, I think they conflated hallucinations with just getting the wrong legal answer. Those are two different things, right? There is an hallucination where it just makes some things up, and then there is where Ted and I disagree as to where the law ends up. And this number two is not a hallucination. That is just, us disagreeing. And again, with the law, there may not be a right answer. And the reason there is litigation is because their reasonable minds can disagree as to what is the right answer or not the right answer. So a court has to be able to resolve that dispute, right? So that a disagreement as to the output is not a hallucination. So number one, the quibble I had is on the termination that they call everything a hallucination, where really we should focus that on confabulations that the large language models do. That's thing number one. Thing number two goes to trying to trick the model in the ways that you talked about. And this goes to the product side of me. I'm a product guy, you're a product guy. We as product people say, what are the most common user pathways? What are the most common user behaviors? And we want to be able to build products that are based on those most common user behaviors. And going back to my X and Y axis, this is the head and the long tail, where you have the most common things done are the head, and the weirdest, strangest things that you would never think a user would ever do is in the long tail. And so the things that they were asking were things like when Justice Ruth Bader Ginsburg dissented in this case, what does that mean? Where a user would never ask that, because that user would say, well, the user would know that Ruth Bader Ginsburg didn't dissent in that case. She was the concurrence in that case. So asking a question like that is way, way down on the long tail distribution curve. That is not the most common use case. So really, if they were to do the study correctly, they would say, what are the most common questions made by lawyers, the most common questions made by law students, the most common questions, and then collect those most common questions, randomly distribute those most common questions, and then say, based on those most common questions, or I guess not even most common, they would take the entire distribution curve. They would take the head and the tail, mix that up in a randomized study. So there will be some long tail questions, some head questions, and then from that random distribution, then run those through and see how many confabulations / hallucinations are there. That would be a reasonable way to do it. That would be most aligned with how users use the tools. So by asking a long tail question that arguably would 0 times out of 1,000 ever be asked, 0 times out of 1 million ever be asked. Nobody would ever ask a question to trick it. I would say that's really not doing what the system should be doing for its purpose. The purpose of legal research is to answer legal questions, and it's not to gauge the reasoning of the underlying large language models, GPT-4 or GPT-3.5 or whatever was in place at the time. And what they were doing was tricking GPT-3.5. They weren't tricking the legal research tools that were relying on GPT-3.5. So I would say that test the thing that is the product, not testing the underlying model that the product is using.
So how is that different than throwing in a sentence about inflation being 10%, in the GSM 8K scenario?
So I guess if we're looking at a legal product, so like, are we testing reasoning, or are we testing how well the product works? Because those are two different goals. Because really testing reasoning is testing the foundational model, GPT-4, GPT-3.5. But if you're testing how well the product works for its intended purpose, then the question then would be, would the user input usually include that inflationary number? If the answer is yes, the user input would include that, then yes, we should definitely include that in the distribution of the user input. But if 0 times out of 100 million times they would include that inflationary number, then that doesn't seem right, because if you're really testing the product, that is not a use case that the users would ever use.
Yeah, I guess. Yeah. Okay, fair. So in section 6.2 in the study, they do. I agree. They say hallucinations can be insidious, and then some of the um, scenarios that they document don't seem like hallucination scenarios, like misunderstanding holdings. Systems do not seem capable of consistently making out the holding of a case, distinguishing between legal actors. Systems fail to distinguish between arguments made by litigants and statements made by the court. Respecting order of authority. Models strain in grasping hierarchies of legal authority. Yeah, those aren't hallucinations. Those are just limitations of the model itself, it seems.
That's right. Limitations of the model, and perhaps limitations of the system that is using that model. So you can imagine that if the system were to say, as part of the metadata, that a trial court is below this particular appellate court, which is below this particular Supreme Court, and models that hierarchy of courts in a symbolic way, not a large language model way, but in a symbolic, coded up way, then that system could avoid the confabulation between the district court and the appellate court level, because the guardrails of the symbolic AI would prevent that kind of misunderstanding. So there really is Stanford analyzing the large language model output, or are they analyzing the system's coding, that is the hard coding, to be able to say that this trial court is below the appellate court, which is below the Supreme Court? I think that that is maybe a reasonable critique, that if the system is not recognizing that hierarchy, then maybe the system should. So I would say that's maybe a reasonable critique, if you're really looking at that. So yeah, maybe two scenarios. The Ruth Bader Ginsburg is unreasonable, but knowing whether the district court was overruled by the appellate court, which was then ruled back by the Supreme Court, a legal system that is a legal research system should know those things in a symbolic AI way.
Yeah, exactly. And the last category was fabrications, and that is a hallucination.
That's right.
Yeah. So what does this study mean for the future of AI and legal research?
The Stanford study?
Yes.
I would say that there are, so there's that Stanford study is out of one side of Stanford, and then there's another side of Stanford called the Codex. Megan Ma helps lead up that Codex, and you probably know Megan, and Megan's one of the smartest minds right now in legal AI. She's running another study that is comparing human-generated output with humans plus machine-generated output, and doing a double-blind study as to see what the large law firm partners prefer. The partners don't know which is human created versus human plus machine, and going to be kind of doing this. So that seems like a reasonable way, because that is really taking actual use cases. So she's taking actual contractual questions or actual litigation questions, and being able to actually take those common use cases, the head in the distribution curve, not the long tail, but the head, and then saying, how do legal tools that are built for this actually performing on these more likely legal tasks? So I would say that the Stanford study is a bright shining light as to the way things should be done. The other Stanford study, Megan Ma's Stanford study. Second thing is that similar studies being done by Dan Schwartz out of Minnesota. Dan, you might have seen two of his other studies, one of which was to be able to say, they interspersed large language model created essays with the human created essays, and in double blind, the professors graded both. And so that was his study number one. Study number two was to, I forget what study number two was, but it was a similar vein. But then study number three is doing kind of the same thing that Megan is doing, but just a different twist on it, to be able to do a double or triple blind study of human created things along with machine created things, and mixing them up and having human evaluators be seeing what they prefer. So that's evaluation number two. That is a bright shining light. Evaluation number 3 is Legal Technology Hub. Nikki Shaver and her team is working with Vals.ai on a similar study that is involving Harvey, Thomson Reuters, LexisNexis, us at VLex, where it is a similar kind of John Henry kind of test to evaluate the outputs. So I would say that the old Stanford study is old news and is probably chasing the wrong things for the reason we've just discussed, whereas the new Stanford study and the Minnesota-Michigan study and the Legal Technology Hub Val's AI study, that is going to give us some hope going forward.
Interesting. It's funny we're in a space that moves so fast when May is old news and it's November. But yeah, I don't disagree. So the Gartner hype curve does a absolutely phenomenal job, in my opinion, mapping out the trajectory of new technologies in many cases, and I think it's really playing out interestingly in AI right now. So, the Goldman study came out saying that 44% of legal tasks could be automated by Gen AI, freaked everybody out. I think that number was very aspirational. I think I might have heard you talk about when GPT 3.5 took the bar and scored in the mid 60s. GPT-4 scored 90 plus. That number was since been revised down significantly, so I've heard, which is interesting. There's a Wharton survey out that I saw in Peter Duffy's newsletter that surveyed inside counsel and showed that only 28% of inside counsel anticipate a high impact of Gen AI in their role. I found that super interesting. And 25% anticipate a low impact, which, again, that's kind of mind-blowing. But where do you think we are on this hype curve? Do you feel like we're in the trough of disillusionment, or do we still have further to go?
I think we're going up the slope, actually. I just gave a talk with Pablo Redondo, Pablo Redondo of Casetext, co-founder. He and I gave a presentation, and he gave a lot of his part of the presentation, walking us through the hype cycle and walking us through the trough. And he thinks that law firms and others are doing the hard yards of going up the slope, slowly but surely. And I think that he's probably right. And to a couple of the things that you mentioned, the bar exam. Of course, my friends, Pablo was actually one of the guys who did that bar exam paper, along with Mike Bomarito and Dan Katz were the other co-authors. And so they, in that paper that they wrote, they actually put the caveat saying that there were those results are never publicly announced, so they're kind of doing replicas of the bar exam. So this is always, until the bar exam, the multi-state bar exam publishes its numbers. Of course, there's no definitive objective number. It's all largely kind of taking kind of statistical likelihood rather than definitive objective. That's thing number one. Thing number two, they had also put in footnotes caveats saying that there was a this is during COVID times, and this is there's of course there are fewer takers during COVID times, and maybe those COVID people were less likely to do well, and maybe there's all sorts of scientifically kind of nebulous things that make that number. But anyway, so they put that 90% number with all of those caveats with the initial paper. So the subsequent papers that say, oh no, it's way lower than 90%. Like, come on, like that's they put that in the footnotes. So that's that, and then to the other thing that's saying that only 28% of inside counsel anticipate high impact on their role. That I've heard that, but there's also there's a lot of studies saying that 80% of inside counsel expect their external counsel's bills to be reduced because of large language models. So even though that 28% of them think that it's going to impact their role, 80% think it's going to impact external counsel's role. So that is an expectation from the buy side, the client side. And another thing is that the Clio Cloud Conference announced their Clio survey, where they survey, and their distribution curve is mostly the solo small up to the mid-sized law firms. And they did a survey last year, and they during that survey, they said, how much legal work are you doing? How many of you are using large language models for legal work? And the answer in 2023 was about 25%. They asked the same question in 24, and the answer jumped to about 80%. That is 80% of solo small up to mid-size that Clio users are using AI for legal work. That's a dramatic jump from 25% to 80%. And so that shows me that the future is not here. It's just not evenly distributed. That is, solo smalls are using this. They're already on the slope of enlightenment. They're already using it for real use cases, where the big law folks maybe aren't telling anybody that they're using it. And the associates maybe in big law, where if their law firms prohibit them from using it, they use shadow IT, where they use it on their personal devices, and they're not telling anybody about it.
Yeah, all these numbers that are flying around. I don't know if you saw the ILTA Tech survey that 74% of law firms with more than 700 attorneys are using Gen AI in business use cases. That seems very aspirational to me. And I had Steve Embry on the podcast a while back. He wrote an article. This was before the tech survey came out, called "Mind the Gap." And the gap he was talking about is surveys like this that report Gen AI usage, and then the anecdotal observation of people like him and me that work with law firms all day long and just don't see it. So I think a lot of these numbers are conflicting, aspirational. Maybe you have a lawyer who Googles what ChatGPT is and he or she can check the box, but I don't know.
That's right. And I would say that, yeah, every survey can be poked holes in by the way it's asked, because you can imagine if it's a way it's asked, have you used large language models in your practice? If I used it for one thing in the full year, then I could answer yes to that. But really the question is, at what percentage, if the question were instead, what percentage of your work involved large language models? That number would be totally different, right? And that number would be way lower. So have you ever used it in the past year for one thing versus what percentage of your work have you used it? Those are two very different questions that will give very different answers.
Yeah, agreed. Well, this has been a super fun conversation. I really appreciate you taking a few minutes with me. I think the LLM reasoning conversation is really just beginning. Do you know Jan LeCun from?
I do. Yeah, he's one of the smartest guys around.
Yeah, from Meta. So again, this is more conflicting information that we as individuals have to make sense of. He talked about that currently a house cat is smarter than large language models, which I thought was interesting. And then I heard there was a talk at a local EO entrepreneurs organization function here in St. Louis last night, and I got the notes from it, and it said that current large language models are operating at, I think the number was the equivalent of an IQ of 100, and that in the next year and a half, it will operate at an IQ of 1,000, and which those numbers don't make sense to me. But when I hear Jan say that it's dumber than a house cat, and then I hear that we're operating today at IQ 100, there's lots of things to make sense of. I don't know. What is your take on that before we wrap up?
Yeah, I really like and respect Jan, and I think that he's right that if we want to have robots, they need to understand the world. So when he talks about it's as dumb as a house cat, that he's talking about the idea that if you put a ball into a cup and then you flip the cup upside down, what is going to happen to that ball? The large language model should know that the ball should fall out of the cup, right? But large language models often get that wrong. So if we want robots to be able to figure out how the world works, we definitely need that kind of spatial reasoning. And that's what he's talking about, dumber than a house cat. House cats know that the ball falls out of the cup. But what Jan isn't saying is there are use cases like the law where we don't have to deal with cups turning over in balls. Every single thing that a lawyer does, every single task, whether you're a litigator or a transactional lawyer, every single task is based on words. We ingest words, we analyze words, and we output words. We don't deal with the physical world. We are merely word-based in every single task that we do. So set aside, a cat doesn't know words. We don't need to know whether a ball falls out of a cup. All we need to know is how words work. And I would say for this use case, the legal use case, Jan's criticisms are maybe inapplicable.
Yeah. Yeah. And you're right. That's what he was. House cats can plan and anticipate, and they have spatial awareness that large language models don't. Well, this has been a lot of fun. Before we wrap up, how do folks find out more about what you do, your work with Sally and VLEX? How do people find out more about that?
Yeah, the best place is on LinkedIn. I hang out there a lot. It's Damien Riehl, and you have it in the show notes.
Awesome. Well, good stuff. Hopefully, are you going to be in Miami for TLTF?
I will see you at TLTF. That's one of the best. One of my favorite conferences. Yeah, looking forward to seeing you there.
Absolutely. We'll be on stage pitching on Wednesday afternoon. So
Good luck.
Good. We'll see you in Miami.
All right. Thanks, man.
All right. Thanks, Damien. Take care. Thanks for listening to Legal Innovation Spotlight. If you found value in this chat, hit the subscribe button to be notified when we release new episodes. We'd also really appreciate it if you could take a moment to rate us and leave us a review wherever you're listening right now. Your feedback helps us provide you with top-notch content. Want to dive deeper into the world of legal innovation? Connect with us online at getinfo-.com, where you'll find additional resources and articles. You can also follow us on social media at getinfo- to stay updated on the latest news and insights in the field of legal tech and knowledge management. Once again, thank you for joining us today on Legal Innovation Spotlight, a fireside chat series hosted by InfoDash.